Welcome to the podcast, Town Hall with State Representative Gino Bulso, District 61. Representative Bulso proudly represents his fellow Williamson County resident and holds town hall gatherings to hear directly from them. These podcasts will continue throughout the duration of the 2023 legislative session of the Tennessee General Assembly. Along with attendees, Representative Bulso will discuss the bills he has filed or co-sponsored in the House. He will review the recent events in the General Assembly, and he will preview the upcoming legislative activity for the state of Tennessee.
Afternoon and welcome everyone. We are now live streaming on our Facebook page this first town hall that we're going to be doing throughout the course of the General Assembly session, which, as you all may know, actually runs 45 legislative days each of the 2 years of each session. So we're April and probably maybe the first week or two of May before we actually conclude the legislative session here in Tennessee. And we thought we'd start these throughout the session really to accomplish three things. One, just to allow anyone in the District 61, any of our constituents, to have a chance to ask questions of me, the representative in the House of Representatives for District 61. Second, just to allow me to report to constituents as to what has happened so far during the session in the General Assembly and to preview what is likely to come up in the next week of the General Assembly. And then third, just to focus specifically on the bills that either I have filed as a prime sponsor or that I've co-sponsored throughout the course of the General Assembly session. As many of you know, any bills to change the law or enact new law in Tennessee have to be filed within the first 10 days of the legislative session in the House. The Senate is a little bit longer, and January 31 was our first deadline for filing a bill. So every bill that could be filed in the House this year has now been filed. And we had a total, I think, just a little over 1,500 bills. Just to give you an idea, we've got 99 members of the House, and for the most part, each member is limited to 15 bills. 100 times 15 is 1,500, and that's about how we got up to 1,500. And we've got a microphone here on the table, as many of you see, because we want any of our constituents at home who are participating on Facebook and maybe asking questions on Facebook to be able to hear everything that's going on. So I've got a mic that will transmit my voice through the live stream connection. And any questions, of course, we'd like you to use the mic as well so that everyone can hear. So without any further ado, we're going to try to keep this to about an hour just to be respectful of everyone's time throughout the course of these town halls. But please feel free to arrive early or to leave early or leave late as you may see fit, because I know everyone's got a very busy schedule. So without any further ado, why don't we start first with questions. Does anyone here have a question that they'd like to kick off the town hall with? Okay, good. We're going to be moving, I'm sorry, Sandy.
I will.
Sandy Wells.
Do you mean a question just about the town hall, or did you get right into legislation?
Anything at all.
Okay, well, may I get right into legislation?
Absolutely.
Okay. Are you looking, or have you been following at all the, it's Whitson and Johnson's bill, Jack Johnson's bill, 0183, which has to do with the change in the political committee campaigns to political action campaigns? And there's a lot of concern that newspapers and places like that are going to be silenced. Have you been following any of that?
Not closely.
Okay.
Is 0183 the bill number in the House?
The House number.
It's 183?
House 0183.
0183, okay, let me just...
That's it. Or maybe 0083.
Let me-
And then the Senate bill is 0160.
Let's see whether we can pull up
'Cause that's a real
0183.
concern to a lot of people.
Mm-hmm. Let me get off the dashboard.
And I had asked Sam for, some further clarification on it, and he said that the bill was still being defined. And Senator Briggs said the same thing. It's actually Briggs' bill, not Jack's, but Jack signed on to it.
Okay.
And, but then I saw last night, it's going to be before the Senate committee on the 7th, which is Tuesday, I believe.
Okay. Let's take a look here. just try to get there this way, Sandy.
Yeah, I'm pretty sure it's 0183.
You think it's 0083 in the House?
Okay.
Make sure that the page should be.
Let's take a look.
But they're probably saying the same thing on the Senate bill, which is 0160. And we had, in 2010, I believe we passed, one of our laws that newspapers and outlets like that cannot be technically silenced. But I don't know if this bill will override that.
Okay, we got it
And then it's
pulled
about
up here now.
expenditures.
This is,
Yeah, maybe you can, yeah, there you go.
let me get that. Okay, so this is House Bill 183 by Sam Whitson. And is this something that you're supporting, Sandy, or you're in
Well,
opposition
I
to?
would like more information about it.
Okay.
If it's what it seems like, and you know how the legal, I guess it's hard to understand sometimes, it seems like I would not be supporting it, but that's why I'm wanting to get further information.
All right, let's quickly grab the microphone just for a second. Chad, can you push that over here? Okay, sorry about that. No, I'm already mic'd up.
Oh, okay.
So I don't think anybody could hear you on the live stream.
Okay.
That's why. So let's just kind of recap. One of the bills that's been introduced is this House Bill 183 by Sam Whitson from District 65. It's also been introduced in the Senate by Senator Briggs. And what was your question or concern, Sandy?
Well, I just want further clarification on it. There's a lot of concern that it's going to be suppressing speech from news outlets and other groups, and I need further clarification. I have asked for it, but I haven't been able to get it just yet. I understand it's going before the Senate committee on the February 7th, and I just need better clarification. But as it is right now, as you asked would I support it, I would not support it. But that's the way I'm reading it, and it's just hard to understand some of the legal language
Okay.
sometimes.
And as we're looking at it, one of the things that we can see is that it's been assigned to the Elections and Campaign Finance Subcommittee in the Senate, in the House, excuse me, and it's been placed on the State Senate Local Government and Committee calendar for February the 7th, for Tuesday. So I will go ahead and pay attention to that, see what happens with it in the Senate, and then we can report back
Okay,
at the
thank
next town hall. It's not, as you can see, it's actually
has to
not
go.
been even noticed for hearing in the House yet. And the way this works, for those of you who aren't connoisseurs of legislative process the way Sandy Wells is, when you file a bill, you have to make sure that you have a sponsor in the other house because the same exact bill has to come through both the House and the Senate for it to become law. And once it's filed, it has to go through 3 readings under the Constitution: a first reading, a second reading, and a third reading. And typically, the first and second readings are done as a matter of course, somewhat just routine in both the House and the Senate. And then once it's been through a second reading, it'll be assigned to a committee, and oftentimes it's assigned to a subcommittee of a committee. And so the process is that when it gets assigned to a subcommittee, the legislator who's the sponsor of it has to put it on notice, which means you have to set it for hearing before the subcommittee. And oftentimes a bill will proceed in one house all the way through the process before it actually starts the process in the opposite house. So that's a little bit of inside baseball as to why this bill that Sandy is concerned about is on schedule to be heard in the Senate on Tuesday, but it hasn't even been calendared in the House yet. All right. Any other questions to start off with? Okay. Let me just go into a little bit of reporting then, because looking at the calendar that we've got for the House of Representatives, we've got a Civil Justice Subcommittee meeting. And for those of you who are looking at the screen and wondering what this is actually something that's available to the public that Speaker Cameron Sexton made available to the public this year. It's called the dashboard. And you can actually go on the General Assembly's website, capitol.tn.gov, and that's capital with an O, and toggle into this thing called the dashboard, which is a very handy tool because once you sign up to use the dashboard, you'll put in a username and a password, and then you can actually follow the progress of every bill, either in the House or the Senate, and see exactly where it's calendared. And you can also see what amendments have been added to a bill as it progresses through the legislative system. And just for example, coming up next week on Monday at 1:30 p.m., we're going to be having a meeting of the Governmental Operations Committee. And that's one of the committees that the Speaker asked me to serve on. I'm serving on and the Civil Justice Subcommittee, also on the Government Operations Committee, and then also on the Education Administration Committee and the Education Administration K through 12 Subcommittee. So the first committee meeting that I'll have this coming week as your representative will be in Government Operations. And as you can see, we've got in Government Operations simply this consent calendar that has about, looks like 22 different bills that have been filed, and they all deal with these things called sunset laws. You know, the state of Tennessee is very efficient, but it does have about 244 different state agencies right now. Every one of those agencies is governed by rules and regulations that have been adopted by the agency and approved by the General Assembly. But the General Assembly actually only allows agencies to exist for a limited period of time. And so whenever that period of time has expired, there's what's called a sunset bill that's filed to renew that particular agency. And oftentimes it's done on this consent agenda because obviously if we have a state agency that's in operation, there's ordinarily a good reason for it to be in operation. And so what you see here on the Government Operations Committee is simply a list of 22 different sunset bills that by consent are going to allow these particular state agencies to continue into existence until the next heavy-duty activity going on in the House this coming Monday. If we look over to Tuesday, we've got the Transportation Committee meeting at Education Instruction meeting at 9 o'clock, and that, once again, is a committee meeting that I'll be participating in as the representative for District 61. But there's not a whole lot going on in the committees right now because most of the heavy lifting is being done in the subcommittees that bills have to pass through before they actually get to a committee. And here, for example, if we look farther down on Tuesday at 1:30, we're having a Civil Justice Subcommittee meeting. And this is one of the committees that, as I mentioned, that I'm serving on. And this is going to be an interesting meeting because first we're going to be dealing with a bill that was filed by Representative Stevens that seeks to delete a portion of the Tennessee Code that deals with having special judges. And this, again, is a little bit of inside baseball. This is not something that really captures the public imagination. But there's currently a statute in Tennessee that provides that if a judge has to recuse himself or herself from hearing a case, that the parties can actually select as a special judge, a retired judge, and pay that judge to hear the case. And it's not a statute that's used a lot, but it's on the books, and for some reason, there's an effort's being made to terminate that statute, that is to remove it from the Tennessee Code so that you can no longer have parties being able to retain a retired judge to hear a case where the first judge has recused himself or herself. So it'll be interesting to see exactly what the reasoning is behind that, but once again, that is not something that's captured a lot of imagination yet. The second bill that we're going to be hearing in the Civil Justice Subcommittee is something that was filed by the Majority Leader William Lamberth that deals with general sessions cases. Once again, this is not something that's going to capture a lot of attention, but it simply is a bill that, if enacted, would change the way successful litigants in general sessions court go about executing on a writ of execution that they've obtained because someone has, in a detainer action, for some reason failed to pay rent or something of that nature. And what you can see here is that there's an effort that's being made to limit to just 2 days the length of time that a writ of possession or restitution may issue after a decision in general sessions court has been rendered. It also provides that the execution of the writ is going to be delayed for expiration of an appellate period pursuant to 29-18-128. So all of that to say that this is simply a way to try to expedite the execution of a judgment pursuant to a writ of possession that may be issued in a general sessions case. As you can see, some of these issues become somewhat arcane to those who don't practice in the legal world very often. The third bill that we're going to consider is actually one of mine. This is House Bill 187 that I have filed in the House. It's been co-sponsored by Senator John Stevens from West Tennessee in the Senate. And this is also somewhat technical, but perhaps a little more understandable just in terms of the scope of it. What this bill seeks to do is to amend Section 20-1-119, which is part of our Civil Procedure Code, to provide that the definition of the word defendant is going to include an uninsured or underinsured motorist carrier for purposes of any comparative fault litigation. And the way this works is this way. Let's say that Sandy is rear-ended by someone who has no insurance, and she's horribly injured, and she has to file a case to recover medical expenses and other damages available under Tennessee law. Because the person who injured Sandy had no insurance, Sandy's attorney would serve that complaint on her own insurance carrier because she very likely has what's called uninsured or underinsured motorist coverage on her automobile policy. And anyone here who's unsure about whether you have it, you want to check, because you definitely want to have uninsured or underinsured motorist carrier, because there's a better than even chance if somebody hits you, they might not have insurance coverage at all, much less sufficient coverage. But when a defendant is sued in a case of this nature, an automobile collision, that party has the right to say, I was not at fault, or if I were at fault, then so were these other parties. And when a defendant does that, say the defendant the person that hit Sandy says, I was swerving to avoid someone else who had just stopped in front of me unnecessarily, that person would say this other driver is at fault, which would then give Sandy's attorney an additional 90 days to bring that party into the case. And right now, the way the statute is written, there's a gap. The statute only allows Sandy or another similarly situated person to bring in a party if that party is named as a party at fault by a defendant. But if Sandy's insurance company, her uninsured or underinsured motorist carrier, says the defendant is not at fault because it was somebody else's fault, right now the statute doesn't give Sandy's counsel that 90-day window to bring in that additional party who might be responsible. This revision would fill that gap and make it clear that whether it's a defendant or whether it's an uninsured motorist carrier who's been served pursuant to Title 56, in either event, Sandy and her counsel have that 90-day period in order to bring that party into the case, which is very important because there's a very short statute of limitations on these kinds of claims in Tennessee. So that's one of the issues that will be before us, before the committee on Tuesday at 1:30. The next bill, the fourth bill, is also, interestingly, one that I filed that also has Senator John Stevens as co-sponsor in the House. Let me go ahead and just open this for you. This is House Bill 39. And once again, this is something that is related to the civil justice system, as you might expect, because it's coming before the Civil Justice Subcommittee. And what is all this about? Well, this is actually something that the Supreme Court asked me to do, because when you have a case that's on appeal, there are certain costs that a litigant incurs in order to prosecute an appeal. And this came up very recently in a case that we actually handled before the Tennessee Supreme Court. There was a truck manufacturer that had a $30 million judgment returned against it by a jury in Jackson, Tennessee. $10 million of that was for compensatory damages, $20 million was for punitive damages. And it involved alleged misrepresentations about the quality of these trucks. These are big tractor trailer trucks, about 300 of them. They cost over $100,000, maybe $200,000 a piece. And after the truck manufacturer, a company called Navistar out of Lisle, Illinois, right outside of Chicago, after they had this unfortunate result in the trial court, they came to us and asked us to handle the appeal. And we said we would be happy to. And one of the things we noticed early on is that the trial judge made a mistake. The trial judge should never have submitted the case to a jury, because the claim that the plaintiff trucking company in this case was making was actually barred in Tennessee by something called the economic loss doctrine. And we won't have time to go into exactly what that is. But we appealed this $30 million judgment against the truck manufacturer to the Tennessee Court of Appeals. And when we did that, we had to file a bond, because when you appeal, unless you file a bond, a plaintiff in a case who obtains a judgment can execute. That is, they can go take your assets. So in order to prevent the plaintiff from going and seizing the trucking company's assets, we had to post a bond. And obviously $30 million is a very large bond. And not all of it had to be bonded because of the way that the statutes work on punitive damages. But a good portion of it had to be bonded. And the bond cost about $60,000, the bond premium. But what was even more difficult was that the bonding company required security. And in order to obtain security for the bond, the company had to post a letter of credit, which ultimately cost $1.5 million, because the appeal lasted for 2 years. So we went ahead and we filed the appeal. We posted the bond so that we'd stay execution, and we were on our way to the Court of Appeals. Well, the Court of Appeals agreed that the trial judge made a mistake. They agreed that the economic loss doctrine prohibited the case even from being submitted to the jury. So the Court of Appeals reversed the $30 million judgment and entered judgment in favor of the trucking company, the manufacturer that we were representing. Well, the plaintiff was obviously very unhappy about that, and so they appealed to the Tennessee Supreme Court. And the Tennessee Supreme Court took the case, interestingly enough. And the Tennessee Supreme Court agreed, once again, with us and with the Court of Appeals that the case never should have been submitted to the jury. And so they went ahead and reversed that $30 million jury verdict and entered judgment in favor of the truck manufacturer. Now, when you're successful in a case on appeal, the law allows you to recover your costs, including the cost of any bond that you have to get in order to take the appeal and stay execution. And when we filed with the clerk of the court our request for fees for the bond, the court awarded the bond premium of approximately $60,000 but said that the $1.5 million that the company had to pay to obtain that letter of credit was not recoverable. And we explained to the clerk that that's not right, so we objected to his finding, and that the objection went directly to the Supreme Court. And Supreme Court said, you know, Mr. Bulso, you're right. The clerk should have given you the entire $1.5 million plus the cost of the bond premium. And so once the whole case was over, Justice Sharon Lee, who's the liaison to the Supreme Court's Advisory Commission on the Rules of Practice and Procedure, which is a commission that I'm currently chairman of, she asked that we go ahead and address this in the law. So what you're seeing here is simply a clarification that if someone is successful on appeal after they've had to post a bond, they're able to recover not just the bond premium, but the cost of any security or collateral to secure the bond while the case is on appeal. So this is not something that came up a lot in the campaign. We weren't really, this is a little inside baseball, but it's something that needs to be done. And so we're kind of shoring up some of the legal issues here. That's also going to be before our committee on Tuesday afternoon. Let me go to something that might be a little more interesting. Also on the 7th, there's going to be a meeting at 4:30 of the Public Service Subcommittee and also of the K through 12 Subcommittee of the Education Administration Committee. And I'm going to actually be involved in both of these. I'm a member of the K through 12 Subcommittee, which we'll get to in just a second. But I'm also going to be presenting to the Public Service Subcommittee a bill on Tuesday afternoon. And this, here it is, it's Bill 487. And this is a bill that was really the whole reason that I ran for office, that I sort of left the confines of the practice of law, left the family behind a little bit, and said, it's time to get involved in public service. Because one of the things that you all know is that the biggest problem we have, I think, in our country, or one of the biggest, is the out-of-control federal spending, the $32 trillion deficit, the fact that we've got no brakes, no guardrails on spending in Washington, D.C. It hasn't always been that way. It shouldn't be that way. And I'm sure I've discussed with many of you how this came to be. And it all goes back to the fact that when you look at our U.S. Constitution, particularly Article 1, Section 8, Clause 1 of the Constitution, it gives the federal government the authority to spend money for only three things: to pay the debt, to defend the country, and to provide for what's called, quote, the general welfare. And that the term general welfare in the late 18th century had a specific meaning. And it simply meant that the federal government could only spend money for the welfare of the entire Union in accordance with the enumerated powers in Article 1, Section 8. The federal government, in other words, could not spend money for the specific welfare of any particular community or any particular state. And that's something that James Madison spells out very clearly in Federalist Number 41. And from the time the country was founded, all the way up until 1936, the courts, the federal courts, including the U.S. Supreme Court, interpreted that thing called the Taxing and Spending Clause, Article 1, Section 8, Clause 1, in accordance with what James Madison wrote in Federalist 41, that, hey, the federal government can only spend money on the debt, to defend the country, or to provide for the general welfare as enumerated in the enumerated powers throughout Article 1, Section 8. But in 1936, something happened. The Supreme Court, during the New Deal era, left behind the Madisonian view of the General Welfare Clause, which sometimes you'll see referred to as the Taxing and Spending Clause. And they adopted Alexander Hamilton's view of that clause. And he was much more of a Federalist, and Alexander Hamilton said that the spending clause actually was an additional grant of power and authority to the federal government. Now, he never said that before the Bill of Rights was adopted on December 15 of 1791, And that certainly was not the view of the constitutional authors. Hamilton was not there very much at all. He got there early on, then left. You recall Thomas Jefferson was in Paris, France the whole time. James Madison was the guy who wrote the thing, and he knows what it says and what it meant. But regardless, the Supreme Court in 1936 left Madison's view behind. They adopted Alexander Hamilton's view, and since then we've had this explosion of not just spending, but the federal government itself. It's now involved in areas that it was never intended to be involved in, that go beyond the scope of its properly delegated powers under the Constitution. And this was actually an issue very recently in the fairly famous case, the NFIB, National Federation of Independent Businesses versus Sebelius, which was the Obamacare case, where ultimately John Roberts wrote an opinion upholding that act under the taxing power, but also agreeing that certain provisions in that act, including the Medicaid expansion provision, was a violation of the spending clause, which was the first time in a significant period of time that any U.S. Supreme Court decision had restricted the federal government's spending authority. Well, now we've got 5 really good constitutional conservatives on the U.S. Supreme Court, plus John Roberts. And so I think if presented with the issue, they're going to go back to the Madisonian view that was in effect prior to 1936. And how we're going to get there is with this revision to Section 8-6-106. And what that statute does right now is it gives the governor of Tennessee the ability to retain counsel in addition to the Attorney General to represent the interests of the state of Tennessee in federal or in state court. And what we're doing is this proposal, which I believe is going to pass the subcommittee on Tuesday. I feel strongly about that because I've spoken to everybody who's on the subcommittee. That what this does is it actually gives the General Assembly, that is acting through the Speaker of the House and the Speaker of the Senate jointly, to retain counsel in addition to the AG's office to represent the state of Tennessee in state or federal court if in their judgment it's necessary. And here it is necessary because the only reason the federal government has gotten to grow the way it has and to abuse the taxing power and the spending power the way it has is because the states have just stood by for too long and done nothing. And that has to come to an end. And what our plan is to have this bill get through the subcommittee, get through the entire full Civil Justice Committee, and then ultimately be approved on the floor of the House. And then Senator Stevens, as I mentioned earlier, is going to be carrying this legislation. He is carrying the legislation in the Senate. So we're hoping that he'll be able to get it through the Senate. And we're hopeful, obviously, Governor Lee will sign it into law. And once that's done, then I will approach Speaker Sexton with the draft of the complaint on behalf of the state of Tennessee under the 10th Amendment, going in and under what's called the original jurisdiction of the U.S. Supreme Court to have them rein in out-of-control federal spending and federal overreach, which I think they're ready to do. And one key thing here is that, when you file cases in federal court, most of the time you have to start at the district court level, a local court, then you got to go to the Federal Court of Appeals, and only then can you get to the U.S. Supreme Court. But there's a certain class of cases that the Constitution, Article 3, Section 2 of our U.S. Constitution, allows to be filed in the Supreme Court without going through a federal district court or a federal court of appeals. And a dispute between the state and the federal government is one such case. So our plan, if this bill passes, is to file the case directly in the Supreme Court and ask them to go back to the pre-Butler decisions of the U.S. Supreme Court from 1936 that embrace this more restrictive view of the words general welfare in the Constitution. So this is a big ticket item, you might say. So I'll certainly be keeping you all abreast about this one.
Time frame of if you get it through here locally before you could, best case scenario, get it at the federal level?
Well, great question, Susanna. And one thing you'll note is that this bill provides that it's going to take effect on July 1 of 2023. So if this passes both the House and the Senate, on July the 2nd, we will file the case in the Supreme Court. And now they've got discretion about whether to take it or not, because they can hear whatever they want. But I believe that they're ready to take this case. And I also believe that we're going to have other states joining us in this effort, because one of the reasons why we have so much difficulty funding our initiatives at the local level and the state level is because the federal government just sucks up all the tax money and they kind of dribble it back to us. And even still, 40% of our state budget is still coming from the federal government with all kinds of mandates in the areas of transportation, education, and healthcare. It's almost like you go back to Federalist 45 that James Madison wrote, where he said that the powers of the federal government in the Constitution that he just wrote are few and defined, and the powers of the state government are numerous and indefinite. And we've got the exact opposite going on, and have had the exact opposite going on for the last century. And I think the folks up there in D.C. and the Supreme Court right now understand that what we're doing is not consistent with the Constitution, and I think they'll be ready to get us back. Because look what they did in June of this year. On June the 20th, they decided that Carson case out of Maine that restored religious liberty. On the 22nd, Clarence Thomas wrote the opinion in that New York State rifle and pistol case, which reaffirmed the Second Amendment holdings from Heller and McDonald. And then on the 24th of June, of course, we had the Dobbs decision, which reversed Roe versus Wade. So I think we've got a Supreme Court that is going to take the same conservative constitutional view of this issue as they took of those issues from June. Okay, so much for the Constitution. Let's go now back to the Education Subcommittee. K through 12 Subcommittee. We're going to have a couple of interesting issues here, but let me just digress for a second, because we get a lot of emails from folks as state legislators. You'd be amazed. But there have been two issues that have been dominating our emails for the past couple of weeks. There's been one bill that's been introduced by a brand new legislator, Kevin Raper, who has introduced a bill that would provide free breakfast and free lunch for all public school students across the state without qualification, regardless of whether you're from a family that's disadvantaged economically or low income or otherwise. And then secondly, there's been a lot of email traffic about this third grade retention program that's currently in effect, which currently provides, as I understand it, that the results of each third grader's test at the end of the year, one of these TCAT tests, is going to determine whether the child is able to progress to the fourth grade, because they need to be able to read adequately. And virtually all of the emails we're getting on the bill to provide free breakfast and lunch for all school children is all running in favor of it. And all the emails we're getting on third grade retention is running against the whole concept of third grade retention. So before we actually look at what's coming up on Tuesday, did any of you have a view one way or the other on either of those two bills? Because there's going to be quite a bit of work and labor involved in dealing with both of them.
Are you asking for an opinion?
Yes, but let me, if I could, just send the microphone down.
Oh, I didn't share.
Oh, okay. Well, then, there's no need. No need. But no, it's one of the things that is helpful about this is just to get feedback from folks in the district, because there are many areas of expertise that neither I nor many other legislators have. And so we want to bring the expertise and the experience of the community to bear on these bills that we're debating.
So did you say breakfast and lunch for every child?
Yes.
Yeah, I'm surprised when you're saying that the emails are in support of that. I would not be in support of that. I realize that people will latch onto it because it's convenience, but I don't believe that putting government in charge of the nutrition that's going into our kids is ever a good plan. And that's not why I'm sending my kids to school.
No.
So I would oppose that. As far as third grade retention, I was a third grade teacher at one point, And I do believe we need to have a high standard, and we should not be just promoting children through the grades without meeting a level of proficiency. I think a lot of that goes back to our watered down curriculum. We're spending too much time on non-academic subjects and not enough time on mastery of skills. But in response to a third grade retention, I am not in support of basing that solely off of the TCAP. I do think we need to have a standard, but one computer-based test that's given on one day out of a school year, and that's what determines if a child is proficient, I 100% do not agree with that. And I was a part of retention conferences for third graders when I taught third grade, and there should be a lot of other factors involved. It should be a team decision. It should be done at the local level with the parents involved, and it really should be based off of that individual child and what is the best solution for them. And so I don't think that the state is the best place for that decision to be made. I don't believe that any computer-based test is really the most authentic way to assess if a child is reading at grade level. Only a teacher who sits with that child and listens to them read can really make that determination. It definitely is not a standardized way of doing it, but when you're putting a child in front of a computer screen to assess their reading, that you're assessing so many other things than actual reading fluency or comprehension. Only a teacher who knows that child, sits with them, can determine, is this a fluency issue? Is this a child who's getting distracted and unable to finish in the time allotted? What is the fluency issue? Is it just that they're reading slowly, but they can actually read the words correctly? The computer test doesn't do any of that. And even a benchmark test like STAR or AIMS-Web, which are used here in Williamson County, those are not capable of giving you all of that data. So I know that's one of the proposed solutions, is to bring in other forms of benchmark, but if they're all computer-based, so having 3 computer-based scores versus 1 or 2, I really don't see the value in just more scores based off of a computer-based test.
Great. Suzanne?
I just want to add thank you, because I think the test on one day, having kids have gone through TCAP and everything, it is so stressful for them. So much emphasis is put on it that they are so under stress. I literally at one point had to tell my children, this is not about you. This is about the teachers and the grade they get for the job they do, and that's not fair to put that on you. So they were so stressed during that, and I appreciate that you're saying that it needs to be a team effort at the local level, because there's nothing about this computer test that can assess if a child can read adequately. And then the point is, if you just have them repeat the year, but no other interventions are in place, then we're just going to have a perpetuating cycle of this child never passing if we don't know exactly where they're not meeting mastery. They need it at the local level and a new plan in place if you're going to do that. You can't just keep repeating the same mistakes over and over again.
Donna Clements?
Hey, so I just wanted to add to that the TCAP, and I agree, because I have a child that, y'all know the driving test that our teens take. I have 4 kids, 3 of them are drivers. I had my oldest daughter aced it. It's like, this never happens. She's the worst driver. She's a fantastic test taker, but she's a horrible driver. And my son, who had to take it twice, is by far like the best driver. But so there's the whole testing element, ADD. I mean, there's a lot of things to take into consideration. I will say that if a child is in consideration, and they sent out the letters in February, what that means is if you're flagged, that student will then go to summer school and do tutoring. That doesn't mean they're going to repeat. And I think this third grade retention is probably a horrible name for it. I heard somebody else say that. But it just means, oh, you're struggling, you didn't do well on this, and then they'll go into a summer school program and hopefully get set on the right path. I think I agree with everything Andrea said. I would also add, I think when we wait till third grade, there's a acquisition time for reading acquisition, just like language acquisitions, 2 to 5 years old. Reading acquisition is probably kindergarten to third is at the end of it. I mean, we need to be doing this before they get to third grade because you're leaving that window when you really know how to read. Like Andre, I taught third grade and sixth grade, so and I'm also on the school board. So working on these things. We're actually working on a policy for school board now that will kind of be our Williamson County version for this. So I know that our policy in Williamson County is that we'll have the summer, they call it summer camp, but that will provide, the state provides that, and we'll have that for, I think it's 2 weeks for kids. But so the letters just went out, I think in February, if kids might be, and not every child's being considered, but I think one test on one day. And I think one thing also to consider is tests are important, but that's any time spent taking tests is time subtracted from learning. It's education time that if we're measuring our kids, we're constantly measuring them. We've got to be careful to get a good balance. So.
Great. Well, thank you, Donna. And frankly, my view is in line with all three of you, because I do think that we need to make sure that at the end of third grade, all students can read efficiently and proficiently. But having that based on just one test does seem a little bit constrained. You would think that the way to measure whether the child can read proficiently would be to determine on the basis of something more than just one computerized test. And I think there's going to be some adjustment in that legislation throughout the course of the year to make sure that that actually happens. And also, I think, Susanna, to your point, to make sure that if after having measured the issue appropriately, you do have a child who cannot read proficiently by the end of the third grade, we need to have immediate intervention, either through tutoring or summer school, because we do not want to have children in the 4th, 5th, and 6th grades who cannot read proficiently, because it becomes clear that their chances for success in life go down by a large magnitude if they can't read by the time they're finished with 3rd or 4th grade. And then on the free breakfast and lunch, obviously no one wants to have a hungry child. And if you know of a hungry child, I think your moral obligation, separate and apart from the law, is to feed the child. And we always want to have a safety net to make sure that we do not have any hungry children in Tennessee, ever. But the idea that we would have a program where, regardless of the family's means, that we have free breakfast and lunch at every public school for every student, I think that does become something of a governmental program that is both unnecessary and sort of violates my idea of what a limited government should do.
Can I add one more thing
Sure,
on that?
sure.
I don't know if you love boys. Do I have to? As a former teacher here in Williamson County, the amount of food I have seen wasted in the cafeterias. I've had to be that teacher on duty in the cafeteria, and they force the kids to take certain items out of certain categories. So they have to take a vegetable, they have to take a fruit, and so on. And I have watched whole apples and bananas, whole cartons of milks, entire trays of food where they took maybe 1 or 2 bites and they dump the rest of it. And legally, you can't do anything about it. You cannot collect those whole unopened milk cartons or juice cartons. You cannot collect that unpeeled banana and save it and do anything else with it. It all has to go in the trash. And that's, I think that goes back to Obama era, Michelle Obama's healthy lunch, whatever she called it, but that it's a huge waste. And so if we're going to go down the road of providing free breakfast and lunch for every child, imagine the amount of food that's going to be wasted.
Okay, great. Well, thank you, Audrey. Appreciate that. Leaving the digression now and going back to the bills that are going to be before our K through 12 subcommittee on Tuesday afternoon, there are a couple things that I'd love to get the thoughts of many of you on, because you've got expertise in these areas, obviously, and we all obviously have school board members here. One of the bills, let me, in the interest of time, just hit the ones that I think are particularly apropos. We've got a bill here from Representative Sapicki that would seek to increase from $200 to $500, that is to increase by $300, the amount that the state or the local LEA has to provide teachers for supplies throughout the course of the year. Do all of you have any reaction to that legislation? It's a bad idea, Audrey. Why do you think that's a bad idea?
It basically, what it means is teachers are sitting there going through catalogs and picking out, wish items for maybe the new updated calendar that they're hanging on their wall, or, I just don't see it as actual instructional benefit. They might be spending it on, supplies, pens or dry erase markers or something like that. But we already have parents sending in large bags of school supplies at the beginning of the year. I do believe that, in the same manner as we do for children of need, we fill in those gaps, but we have a lot of children that are not in need, and parents are happy to go through a wish list and, go on Amazon or Target or whatever and buy whatever that teacher has on their wish list. I don't think we do it this way.
Okay. Any other thoughts from anyone about that? Great. There's also a second one coming up on Tuesday that is interesting. This is House Bill 252. And under current law, if you send the child to public school, you have to provide evidence of the required immunizations and vaccinations. If you are homeschooling a child, you nevertheless have to provide those same evidence of those same immunizations and vaccinations, according to the current law. This is a bill by a new representative, Jody Barrett, out of Dixon, that would seek to amend the applicable statute requiring evidence of the immunizations, such that if you actually homeschool a child, you are not required to go to the local agency and provide evidence that your child has been immunized or vaccinated against any childhood illnesses, which is an interesting concept. Now let me ask the same question. Does anyone here have any thoughts about this approach, where you effectively allow parents to decide on their own whether to provide certain immunizations or vaccinations for their children? I see you shaking your head again, Andrea. Okay.
And I don't want to be a hog. Someone else needs to speak.
Okay. Does anyone else have an opinion about this?
Well, I mean, shouldn't it?
Sure. If you could just tell us your name first.
I'm sorry, what?
Just tell us your name first and then.
Oh, I'm Ann Grover. Nice to meet
Ann,
you all. Sorry
nice to
I'm
meet you as
late.
well. Oh, no.
Well, I just feel like it should be, I don't have children yet, but, we moved to the state for the conservative family values. And so if I do have children, I don't want the school board or the district to determine what I have to vaccinate my child with or don't vaccinate my child with. So I just feel like if they're homeschooled, like what does it matter? They're with their parents. It should be the parents' choice, I think.
And I think that's the rationale behind this particular piece of legislation.
I concur.
Okay, good. Stu? Yeah.
As a physician, although I support the conservative agenda and I support the value of individual decision-making for our children, as a physician, I also have some concern about the general health of the public. And there are certain diseases which can be checked and arrested and essentially eradicated if people cooperate with vaccination programs. Polio for one, measles for another. These are things that we don't think about much anymore, but they can be very, very serious epidemics once the level of immunity falls in the population. So I think it's a difficult issue because there are strong arguments on either side, but I just wanted to voice my particular concern as a healthcare provider.
Okay, Thank you. And Stu, if I'm not mistaken, your specialty is oncology?
Oncology.
Yeah. Yeah. Ann?
Just to follow up with that, yeah, I do believe that children can be vaccinated for polio. I mean, it's been eradicated, but at the same time, you also have a lot of immigration coming into this country, and we don't know if they're vaccinated or not. So, like, if they don't need to get vaccinated, and we don't need to know if they're vaccinated, why would we be forced to vaccinate our children?
Hello, everybody. I'm Mike Jones, a retired Army colonel. Actually, a unicorn. I was born here in Middle Tennessee. Went away for 30 years, and when I came back, boy, was I surprised. I grew up in Antioch when Antioch used to be a nice place. And it was at one time. Anyway, I digress. But as a 30-year Army veteran, we homeschool our children. One's captain in the Air Force, one's a sergeant in the Army, and we immunized our children according to the required things. We were all over the world. We were not anti-vaxxers. I think that unless there's an overriding desire or reason for the absolute common good, that parents' rights need to overcome everything else. Okay? But I think that practicality comes in too. My concern, though, is today it's polio. We're all against polio. We all vaccinate our children against polio and the various things that need to be and have been greatly eradicated need to stay eradicated. My concern with what happened during COVID, and who's to say what the next vaccine will be mandated, because it's in the public good. By God, we've got to do this, and if you're not doing it, you're crazy. And a lot of parents, maybe not in Tennessee, thank goodness, did withdraw their children from schools because of whether it's masking or vaccination requirements. And in Tennessee, I think people are coming here because of the parents' freedom and our belief in that. And maybe I'm not really going anything. My biggest concern is less about the vaccination. It's about who determines what vaccinations are being required. And that's it.
Okay. Thank you, Mike. Any other thoughts or comments on that issue? We got one more?
I'll just add one quick thing that.
Sure.
Additionally, our trust in those who develop the vaccines has decreased quite a bit, as well as where they're being manufactured. So there's not a lot of trust, in my opinion, with where they're coming from. Thank you.
Thank you. Let me go back, and that looks like that's going to be that's actually the last bill that's coming before the K through 12 subcommittee on Tuesday. Let me just, before we conclude, because we're about at an hour, just show everyone one thing, and that is that when you go on the General Assembly website, which is capital.tion.gov, as I mentioned earlier, you can click on House members, and you can come right down to each representative's name. And here's mine, for example, and there's a button that says Bills. And if you hit that button, it actually will show you every bill that I have introduced in the General Assembly and what the last action is on it and when the last action was taken. So if you want to keep up with the bills that I'm actually the prime sponsor of, this is a great way to do that. And then there's also a tab for co-sponsors. I've co-sponsored 15 bills so far, and those are all right here as well. So it gives you a good idea as to exactly what I'm doing on your behalf as your representative. And obviously I'd love to hear from you as to whether you support these bills that I've sponsored or co-sponsored, or whether you oppose them, because I guarantee you we'll absolutely take your thoughts, comments, and suggestions into consideration, because we've got approximately 70,000 people in our district, and I represent every one of you, and I'll be happy to listen to each and every one of you at any time. There is one one bill that I have filed that is going to be coming before the K through 12 subcommittee, not this week, but the following week, that I want to highlight. And this is House Bill 306 and Senate Bill 1237. It's being sponsored in the Senate by Senator Joey Hensley, who has got actually part of Williamson County in his district. And this seeks to amend Title 49, Chapter 50, Part 8. And here's what's going on, and here's why I have proposed this. Last year, the General Assembly passed a law that said any public school middle schooler or high schooler who competes in interscholastic sports has to do so in accordance with the student's biological sex, which would be evidenced by the child's original birth certificate. And that is a bill that I obviously was not there to work on, but it's one that I would have supported had I been there. But it's one that just applies to public schools. It doesn't apply to non-public schools. And I heard from many in our district who have children in schools other than public schools about the fact that they felt as though the private schools were not protected by that law. And I went and actually spoke with some of the members of the Education Committee from last year to say, why is it that this statute only applied to public schools? It didn't apply to all schools in Tennessee. And the understanding that I received was that because Tennessee didn't have jurisdiction to pass a law that would actually affect private schools, and in particular, the enforcement mechanism that was in that statute was a withholding of funds from the LEA, the local education association, if in fact there was a violation. And so last year, the Education Committee thought that they couldn't quite legally reach private schools. But one thing that I think may not have been completely analyzed last year was that we do have this body, the statewide body called the Tennessee Secondary School Athletic Association, better known as TSSAA. And that, of course, is a statewide association that public and private schools participate in. And in 2001, the U.S. Supreme Court actually held that TSSAA was what's called, quote, a state actor. That means for legal purposes, it was to be viewed as an arm of the state. And that ruling by the U.S. Supreme Court was consistent with those of federal circuit courts across the country that had similarly held that statewide athletic associations are state actors for statutory and constitutional purposes. And so what this proposed legislation that I have introduced does, as you can see, it says that in connection with an interscholastic athletic activity or event where membership in the TSSAA is required, a student enrolled in a private school in this state is eligible to participate in such athletic activity or event only in accordance with the student's sex as defined in Section 49-2-802, which defines sex as biological sex as determined by the child's original birth certificate. So effectively, what this bill would do would be to extend the protections that are in place currently for public schools to non-public schools across the state and ensure that we've got girls participating in girls' events and boys participating in boys' events. And that, of course, is not out of a lack of charity for children that might be struggling with what's called gender identity or gender dysphoria or gender fluidity. Obviously, we've got nothing but care, but compassion for children that are experiencing difficulties with those issues. But with charity also comes truth. And the truth is that we've got two kinds of children in our schools. We've got boys and we've got girls. And regardless of what some in our public education system may think, we don't have more than boys or girls. You're a boy or you're a girl, you should participate in accordance with your sex. And we say that with all respect and with all compassion to any family that is experiencing some difficulty with this issue. But this is a bill that I'm actually going to ask the Attorney General for an opinion on with regard to its constitutionality. Because typically, the state of Tennessee cannot make rules for private corporations. And TSSAA is a voluntary, privately chartered, nonprofit corporation. So something like this is only possible if, in fact, what the U.S. Supreme Court says with regard to TSSAA being a state actor would apply with equal force in this context. So this will be slowed down just a little bit because I want to get the Attorney General's opinion on the constitutionality of it. And if in fact it's something that the AG's office tells us that they're comfortable with from a constitutional perspective, we'll go ahead and notice it for hearing before the K through 12 subcommittee, and we'll be on our way with it. And we're now just a little bit over time, but I'll open it up one final time for any thoughts, comments, questions, or suggestions before we close. Yes?
Hi, I'm Amy, by the way.
Amy, thank you.
I would just say that the rights of the private and public schools, as everyone probably knows, play each other.
Oh, they do.
And so the rights of the students, the athletes in the public schools are, in my opinion, being affected if they're matching up against males in the female sports, or I'm not sure it would work the other way, but you see what I'm saying.
And that's really the genesis of this. One of the private schools in our district raised the issue when Harpeth Hall was going through what it went through a few months ago about having their lacrosse teams playing each other, and a concern about some of the safety of some of their girls if you had someone who wasn't a girl but just someone who was identifying as a girl on the Harpeth Hall team on a lacrosse field against an all-girls team. And that obviously raised some safety concerns, not to mention the privacy concerns that are there all along. Mike?
Representative, thank you, first of all, for hosting us today. Very welcome. And I had a lot of people that wanted to come, but it was during a work day. And I was just going to ask if periodically, if we could have these maybe, in the early evening so that more people who are working could maybe attend and be able to talk to you and you to hear from them. But I just want to say how much and refreshing it is that you would take your time. We know you're busy and we appreciate you listening today. Your humility is very refreshing. Your transparency even more so. And we just want to say thank you.
You're very welcome, Mike. And that's a great point. And I might even go so far as to say that maybe even the next town hall we have we'll do in the early evening to accommodate those who can't be here during the course of the regular workday.
I had to let myself off for a couple hours just to come here. So.
Okay. You gave yourself a note.
I gave myself a note.
Ann?
I do have a question, and it doesn't have anything really to do with that, but it's more about privacy laws in the state of Tennessee. I recently have started to remove my digital footprint. So I'm removing myself from applications that I may use. I was hacked 2 weeks ago, so this is like a whole thing. So I'm removing myself from applications that I no longer use, like Domino's or Tiller's. Okay, I'm going to use those as examples. And I have reached out to the companies and I said, hey, could you please delete my information from your systems? And the only thing that they can do right now is suppress my information. They refuse to delete it because they actually take my data and they sell it to third parties. And so I started to do a little bit of research, and I noticed that Virginia and the state of California as well have these privacy laws as far as digital footprinting goes. And I just was wondering if we could maybe get something rolling, or maybe we already have something rolling that I'm unaware of, about our privacy, our digital privacy laws in the state of Tennessee.
Okay. It's a great question, and let me just ask that you take one of my cards that's here on the table that has all of my contact information, including my mobile telephone number.
Oh, great.
And I will check on this for you, but if I haven't called you back in 2 weeks, and call my number on that card, and I'll make sure that I can find out first what the state of the law is here in Tennessee and whether it's something that we can address.
Thank you, I appreciate
Okay,
that.
sure. Any other comments or thoughts from anyone? Okay, thank you all very much for coming. It's been a delight, and we'll see you at the next town hall.
Thank you for listening to the podcast, Town Hall with State Representative Gino Bulso, District 61. You can also tune into these town hall meetings live on the Gino Bulso for State House Facebook page. Please share with your friends and family. Thank you, and God bless.